What's going on?
Why not?
Yeah,
Shit,
ready.
I don't care about no phone.
Yeah, ready. Yeah, ready. Yeah, I'll come back there and talk. Yeah.
I got kids.
Ms. Beza just went away. Ms. Beza, you still there?
Yes, Your Honor.
Mr. Hudson just went back into lockup to talk with his client. When they come out, are you ready to go?
Yes, Your Honor.
Great, okay. Ms. Nelson, where are all these things coming from?
Miss Crawford, she's been busy.
Apparently, all right. Mr. Hudson, you ready?
Yes, Judge, I am ready. At the court's pleasure.
Okay, well, I think we'll get started. Ms. Beza, you ready?
Yes, Your Honor.
All right, well, let's go on the record. This is case 20 SC 176-859, State versus Adonis Hurd. Good morning, Mr. Hurd.
Good morning, Your Honor.
How are you, sir?
Fine.
Mr. Hurd, we are talking today about bond. Mr. Hudson, your lawyer has filed a motion for bond. It's not his first one. He filed one before your case was indicted as well. But the case has been indicted now. I'm Judge McBurney. The case was assigned to me. So I will be presiding over whatever happens with the case. And one of the first things we're doing is talking about bond. Let me make sure. All right, you've already waived arraignment. You did that about a month ago, Mr. Hudson, and now we're talking about bond. I'm going to give Mr. Hudson a chance to make the argument he wants to make. Ms. Beza, the prosecutor, you may be able to see on the screen right there. She's going to share with me her perspective as to what should happen. It may be that I hear from Ms. Jackson's family. They may be listening in. They're entitled to do that, and they may speak directly. They may speak through the prosecutor or an advocate for Ms. Jackson's family. And it may be, although Mr. Hudson says probably not, that members of your family or supporters for you have something to say. But I'll certainly take note that they are here as Mr. Hudson tells me about why you ought to have a bond, or if your bond is too high, what it should be set at. And I'll let you know what we're going to do, okay?
Okay.
All right. Mr. Hurd, I noticed you came in on crutches. I read the bond motion. I understand you suffered some injuries too about a year ago. Are the crutches related to the injuries you sustained?
Yes, sir.
Are you on any pain medication right now?
No, sir.
Okay. I need to make sure you were going to be able to understand what we're talking about. All right, Mr. Hudson.
Thank you, Your Honor. And first of all, I want to thank Ms. Nelson for finally scheduling this motion for bond. As you know, Your Honor, I've also filed a speedy trial demand on this case as well. Also, Your Honor, Ms. Baser has provided me with all the discovery. Ms. Baser, I did get all the discovery that you had sent over to me, so I appreciate that. So my discovery complaint is no more. I got everything I need. We'll just basically wait until jurors get back if we're gonna move forward with this case. Your Honor, this is why we're here. It was a tragic incident that happened on February 14th, 2020, on the 14th going to the 15th. It was actually approximately about a year ago, Valentine's Day, actually. My client, Adonis Hurd, and his girlfriend, Yolanda Jackson, was traveling. In a nutshell, Judge, because I'm not gonna try the case here, I'm just gonna lay the facts out. They was horse playing at the West End train station. And then they had been drinking a night of alcohol. They spent Valentine's Day together. And they was going to Lakewood, Fort McPherson station. It's all on the same line. And as they was going up, I think they was leaning on the rail. I don't know if we have it. There's no video footage of the Lakewood incident, but it is of maybe the West End incident where they was horse playing around. And as they was leaning back, in a nutshell, Judge, they fell from the top floor onto the pavement.
At West End or at Lakewood?
At Lakewood.
Okay.
Is that correct? That's
That's
what I'm basically saying?
The railing broke.
All right. Now, Ms. Jackson suffered, she was fatally wounded from her injuries. He had a broken torso and other injuries that still to this day haven't healed. He broke his hip, his torso, I believe his pelvis. He was on a walker, Judge. They had him in the medical.
Wheelchair.
Excuse me.
Wheelchair.
Oh, and in a wheelchair. They had him in the medical ward for a long time. He just started back walking about 4 or 5 months ago. Judge, looking at the case in itself, it's and also he had a small amount of cocaine on this person. So it correlates to the fact that they were partying, and they young, Judge. I mean, she's in her 20s, he's 35. Judge, I don't believe that was malice intent. We're gonna have to argue that point to the fullest, like in trial, because they charged him with felony murder. Not saying that the charges are valid, but you know, the intent is gonna be a mean element when given the fact that he was intoxicated and she was intoxicated. And I believe the ME report would say that she had alcohol in her system, as well as he had cocaine in his system. Judge, that's the basic facts. And I know Ms. Baser gonna maybe cross-examine those facts, but that's gonna be our position. Now, my client doesn't have not likely to reoffend. He does not have a violent history, Judge, at all. I believe he had a prior burglary where he was, that case was non-pros, and I believe it was, yeah, and I believe Ms. Jackson was a co-defendant at the time, but somehow it was dismissed. Not likely to intimidate any victims or witnesses. Y'all, he loved Ms. Jackson. I don't know what sparked him to horse play around that day after they got to drinking and pushing and playing. However, Judge, in itself, my client was being more negligent than anything. If he's playing and pushing, and Judge, I'm sorry to turn my back. I'm not turning my back on the court. I'm actually making sure I got the story right because we went over this so many times. In the effort of him playing, she pulled him down. Like he was playing, they was leaning on the rail. She pulled him down and he fell too. When he woke up, he found out she was dead. He woke up in the hospital. She was deceased. It's tragic, Judge. That not likely to intimidate any witnesses. Not likely to. He's not a flight risk, y'all. His mother was Dion McIntosh is here. His daddy, Michael Hurd, was going to be here, Judge. He was at the initial arraignment when I had waived it, but he had to work. So mom, aunties, and sisters came down, as well as other family support over here. So Judge, he got ties to the community. He's not likely to reoffend. He's not a threat to person, places, or property. Judge, this was a tragic accident. I want to talk to Ms. Baser off the record, and not off the record, but not while we record it, try to pre-try the case. You understand what I'm saying, Judge? And hopefully I even have to maybe talk to Ms. Willis, the DA of Fulton County, to test to see how can we resolve this. But the intent is not there. He's not a flight risk. He's not likely to reoffend. And prior to this, Judge, he was working actually at Material Emotions in Fairburn, Georgia, under the direction of, let me see. What's your supervisor name?
Ronnie Sorrow.
Oh, Mr. Ronnie Sawyer, or Sawyer, I should say.
Sorry.
All right, and I remember he was working there for about a year in Fairburn. He lives in Fairburn with his mother. He was working at 1000 Logistics Center Drive, Fairburn, Georgia, 30213. He has no history of failure to appears. He would reside with his mother at 4945 Pecan Wood Circle, and that's Pecan Woods Circles, 2 words, common spelling, Fairburn, Georgia. Also, I wanted to point out he's 35 years old and a December 2004 graduate of the Youth Challenge Military School in Fort Stewart, Georgia. So, Judge, given the Ayala factors, he's not likely to intimidate any victims or witnesses. He's not a flight risk. He has ties to the community. He was working, being a productive citizen. And Judge, he's very remorseful about the incident. I've advised him not to speak at this point, but he really wants to make a statement to the victim's family. But I told him he's gonna have an opportunity to do that. He's remorseful, Judge. His mother, Ms. McIntosh, Mr. Hurd, as well as their families were close-knit families, Judge. So not like your typical murder case where, it was some type of, ill will between the parties. He had no ill will toward Ms. Jackson, and he's very regretful. And he's had over almost a year to think about his actions, Judge. Initially, he had a motion for bond sent by Judge Whitaker. That was before I was attorney. That motion was obviously denied, Judge. That was when he first got arrested, and I wasn't expecting him to get a bond. But clearly, after 12 months, a full year in jail, Judge, I think a reasonable bond, given the fact that anywhere from 25 to 50,000, given the facts of this case, that's where we are. Judge, to be further honest, I don't really want to try this case. I will if I have to. I mean, this is not a case where it's a clear-cut aggressor and a victim here. Like, this was 2 people that was in love, and it happened on Valentine's Day. So, and it just, I think it's tragic for what happened to Ms. Jackson. I'm gonna let Mr. Hurd make his statement, but not right now. But Judge, given the fact, I think anywhere from 25 to 50,000, a good bond with, however, Judge, I would recommend that he be under an ankle monitor, that he get all his medical appointments. I think they've been good at the jail about making sure he's straight as far as health-wise. They've been on top of him, Judge, but this case doesn't qualify for a no bond. Now, usually, person have a lot of history, no bond for whatever reason, but this is an accident. Even if you're not inclined, Judge, final point to follow my recommendation, I still feel that, and Mr. Hurd feels that a bond is warranted in this situation. However, I would personally want him to have an ankle monitor, not that he's going anywhere, but just monitor his behavior. He could be on 24-hour curfew. He's not working no more. And Judge, and that way he could get the medical treatment for himself, really medical and maybe religious worship. Then he need to be at home.
When you're referring to medical treatment, it's treatment for the injuries that were sustained when he fell also.
Yes, Judge.
Or is there a separate medical situation?
No, Judge, there's no separate medical incident, Judge. And like I said, the crutches from when he was in there, like, it's been almost a year because we was in the pandemic before he was able to even come to court. But Judge, he was really messed up bad. He was on a walker. He wasn't even on a walker. They had him on a wheelchair. They was bringing him down to the first floor. And actually, our first encounter, I had to go up to the floor to his room because he was tied to the bed because he couldn't even move. So, but the jail been really working with him, getting back on his feet. Hopefully, Ms. Basin and I can resolve this case. Like I said, there's not one of the cases I'm standing up and down and like trying to be number 1 on the trial calendar like I am with Harold Heath. I'm not trying to really try this case, Judge, but I do feel that my client deserves a bond, or not deserves, but maybe is entitled to a bond, given the facts and the circumstances of this case. Thank you.
Appreciate it. So, Mr. Hurd, how long have you lived at the Pecan Wood Circle address? Or were you living somewhere else at the time? You don't have to stand up. It's okay. You stay, just be near the microphone. Were you living at that address in February of last year, or were you living somewhere else?
Yes, sir. I was living there.
With your mom?
Yes, sir.
Was Ms. Jackson living with you, or she was living in her own place?
She was living in our own place.
Okay. And how long had you and Ms. Jackson been talking to each other?
For like a year and a half, maybe.
How long had you known her?
For that long.
Okay. So if you got a bond and made that bond, you would go back to your mom's house.
Yes, sir.
Doesn't sound like you're gonna be able to, what were you doing at Materials in Motion? What was your job?
QA technician,
But you're on your feet?
quality control. Yes, sir.
Okay, it doesn't sound like that's the kind of job you can go back to anytime soon.
No, sir.
Okay. Do you have kids?
Yes, sir.
How many kids?
2 kids.
Where are they?
With their mom right now.
But geographically, is that in the Atlanta area or are they in Texas? Or
Atlanta.
Atlanta, okay. And they're with the same mom?
Yes, sir.
What are their ages?
10 and 8.
10 and 8, their mom. And a year ago, before this happened, were they living with you or they were living with their mom?
They were living with their mom, but they spent a lot of time at our house too.
Okay. So you've got family in the Atlanta area, you had a job in the Atlanta area, and your kids are in the Atlanta area.
Yes, sir. That's
All right.
correct.
Okay, thank you.
John, I want to point out, not this, I guess Metro Atlanta area, but he's really a Fairburn, Georgia resident.
Okay, I view that as correct. And Fairburn is its own city. It's got its own mayor, its own police force, but it's Fulton County.
Right.
So one big happy county.
Okay.
But I appreciate you flagging. I heard you. You did say Fairburn, and his job was in Fairburn as well. Ms. Beza, this is different. The basic facts seem very different from the murders we too often see. Tell me what you think about bond for Mr. Hurd.
Yes, Your Honor. It is the state's position that bond should be denied on this case. As to the allegations of this case, in February of 2020, at the Martyr Lakewood Station, the defendant and Miss Yolanda Jackson were both at the station. Was I unmuted?
Not the whole time. You said they were both at the station, and then you were sort of gesturing and you muted yourself.
Okay. And CCTV video surveillance from the Martyr Lakewood Station. It is shown on the video that the defendant pushed Miss Jackson to the ground. He drug her up the stairs to an overpass, and then he pushed her over the overpass, causing her to fall 26 feet to the ground below. And she suffered injuries that resulted in her death. The entire incident is on the CCTV surveillance video. While as he pushed her, she attempted to catch her balance and held on to him, and that resulted in him falling over the overpass as well. There's an independent witness that was mentioned, who's named in the indictment, Christopher Alayan, who's the one that called 911, and this independent witness heard the defendant and Ms. Jackson arguing. He did not witness the push, but he heard the arguing and what resulted, therefore, he called 911. Those are the allegations that the state will be proving if this case were to go to trial. I also wanted to speak first about the procedural history of bond in this case, and then the notion that the defense stated in his motion and here in court that there's no prior violent history between the defendant and Ms. Jackson. As briefly, I know Your Honor has all the dates, but as brief procedural history, pre-indictment, bond was initially denied in this case on February 20th in front of Judge Borski, and pursuant to that order, bond was denied given the nature of the offense and the defendant's danger to the community. The prior attorney, Eric Chow, filed a bond motion, and on on March 12th, a bond hearing was set, and Judge Whitaker denied bond because of the following reason. All of the IOLA factors, which I will be discussing today. Judge Whitaker denied bond because the defendant poses a significant risk of fleeing from the jurisdiction and failure to appear in court, poses a significant threat or danger to the community, accused poses a significant risk of committing a felony pending trial, and he poses significant risk of intimidating witnesses or otherwise. All said reasons why Judge Whitaker denied bond are the IOLA factors, and they apply today, and I will be arguing that in my verbal argument. Since then, besides the case then being indicted, there's been no changing circumstance or material changes that would warrant a bond on this case. The fact that the defendant has no felony convictions and the facts or the allegations of this case were known prior when Judge Whitaker denied bond. Now, the defense argued in his motion and also here in court that the defendant and Ms. Jackson did not have a prior violent history between them. I want to clarify the burglary case that the defendant, that the defense attorney, Mr. Hudson, mentioned in court today. And yes, that ended in a no pros. It was 19 SC 170919. However, the defendant and Ms. Jackson were not co-defendants in this case. Ms. Jackson was the victim in this case. In August of 2019, the defendant entered her residence through the bathroom window, without her permission, without her consent. And then he took $310 from underneath her pillow in the bedroom without her authorization. She was the victim in that case. As to other prior violent history, and if this case were to go to trial, I expect to prove this at trial. I've spoken with the victim's daughter, Ms. Jakia Dixon, who's also watching on the YouTube live, as well as her brother and some of Ms. Jackson's friends as well. So they are present. They're watching on YouTube. Spoke with her daughter, who stated that in the summer of 2019, the defendant broke Ms. Jackson's leg and she received medical treatment at Atlanta Medical Hospital. She told me that he had a controlling relationship over her. I've also spoken with one of the victim, Ms. Jackson's friends, who witnessed in the summer of 2019, he personally witnessed the defendant grab Ms. Jackson by the neck when he was drunk, and he stopped him. These are two different incidents with a family member and a friend of prior violent history between the defendant and Ms. Jackson. Unlike what Mr. Hudson is saying and put on the record today, it is the state's position that this wasn't a happy relationship. This was a relationship of domestic violence. Therefore, I wanted to just put that on the record. As to the Arraignment factors, Your Honor. One factor is that the defendant poses no significant threat or danger to any person, to the community, or to any property in the community. Your Honor, the defendant, even though he has no felony conviction, he has run afoul of the law previously. He was arrested in 2019 of burglary relating to this Ms. Jackson. He was arrested in 2020 on the charge of murder relating to this Ms. Jackson. His actions have escalated these last 2 years. He's a significant threat to the community. Not only that, this incident happened at a MARTA station. This incident happened at a public place when people were around. And this incident resulted in the death of a person. This is a clear danger to the community. As to the factor of he poses no significant risk of committing any felonies pending trial, the reason he hasn't reoffended, obviously, this last year is because he's been incarcerated. However, as I stated before, when he's been out recently in 2019 and in 2020, he was arrested both years for felonies. This is indicative of a potential risk of committing future felonies if released. And it's indicative of the defendant's likelihood to commit these offenses in public, as the 2020 incident happened in public. As to the Iola factor poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice, this defendant definitely poses a risk of intimidating witnesses and obstructing the administration of justice. This was an intimate partner relationship between Ms. Jackson and the defendant. There's a connectivity between the defendant and the victim's family and friends. He knows her family, he knows her friends, as Mr. Hudson stated. If this case were to go to trial, I'll be calling both her family members and friends to give the court an indication of how their relationship was. They would be witnesses in this trial. Those witnesses would speak about the abuse that they've witnessed between the defense and Miss Jackson. He will have an opportunity while out on bond to try to intimidate those witnesses and contact the family. This is a grave concern given the nature of these offenses, of these charges.
Ms. Beza, do you have any information that suggests that Mr. Hurd or anyone associated with Mr. Hurd during the past year has made any effort to contact any of these witnesses that you're describing?
No, not while he's been incarcerated.
Okay.
If he were to be released, Your Honor, and pursuant to all the factors I just described, he poses a risk to the witnesses in this case, to the community, and also to committing further and significant felonies if he were to be released. And therefore, it's the state's position that bond should definitely be denied in this case.
So the primary factor that I'm supposed to consider is risk of flight. Tell me what concerns you have about Mr. Hurd not showing up for court when he's supposed to, if he had a bond with an ankle monitor.
Given the nature of the charges, Your Honor, and what he faces if he were to be convicted at trial, he poses a grave concern not to show up in court, given what he risks if this case were to go to trial. He risks prison time, a lifetime of prison, if he were to be convicted in this trial. And so I understand Mr. Hudson stated that he has ties to the community, but given the nature of these charges and the sentencing, if he were to be convicted, that in itself poses a risk of flight.
Okay. And you agree, I don't think we have our probation officer with us today. You agree, Ms. Beza, that there's not a felony criminal history for Mr. Hurd? I appreciate there was the burglary. I've looked at it as you were talking about it, but that was dismissed. So no felony convictions for Mr. Hurd?
He does not have any felony convictions.
Okay, great. Thank you. I appreciate that. Mr. Hudson, anything you want to add?
Ms. Baszler, thank you for your honesty. I appreciate that as well. Your Honor, the only thing is, ordinarily, I just want to mention the 19 and 20 incidents. He gave me further information about that. They was sharing some type of apartment at the time, and I think he took $300 of their money. That's the burglary, but eventually got dismissed. And Judge, just point out the fact that Ms. Mason stated his crimes have escalated. Judge, it's 35. It's like from 17, which age of Fulton County jail or juvenile history, none of that. That just started happening. So he really doesn't have a history to say, well, each year he's escalated. This was a terrible accident, a terrible incident. However, if the state want to say incident, I say accident. However, hopefully we can have a meeting of the minds and come to a resolution short of trial. But in the meantime, during the pendency of this case, and Your Honor, if a bond is given, I plan on discussing this case with Ms. Baszler, and hopefully we can resolve this case short of trial, so that way he doesn't have to continue to sit here. But given the fact of the not necessarily the issues in the case, but the fact that he meets the essentially, Judge, he falls in line with our Ayala factor. So I'm asking for a reasonable bond, Judge, but also I did want to not only add an ankle monitor, Judge, but I want he got a drug problem too, drug and alcohol. I noticed, I didn't know that until Ms. Baszler actually pointed it out. I mean, it was Valentine's Day when this incident took place, but people drink on Valentine's Day and have fun and party. But the fact that another incident occurred that I didn't know anything about because I haven't spoke to the witnesses that she's referring to, but it sounds like my client may have an alcohol and drug problem. So I want to order that too as part of the conditional bond.
Okay.
Also,
Well, let
Your
me
Honor,
tell you where I am right now with this.
Excuse me, Your
I don't
Honor.
find, yes? I'm sorry,
I
Ms. Basil.
apologize for interrupting you. I forgot to mention that Ms. Rolak has statements from the victim's family.
You're right.
I
That was
apologize.
an appropriate interruption, and I had it on my list of folks to check with. So, Ms. Rolak, please share with me what you've got.
Good morning again, Judge. I have from 3 family members. I'll start with the brother. His name is Jafari Hall, Jafari Hall, Hall. I think that Adonis Hurd should not get a bond because he's bound to meet another young lady and abuse her in the same way my sister lost her life. I would hate to hear that the next lady he meets loses her life to violence because it appears that he is very violent behind closed doors. I don't think he deserves a bond due to his history of abuse to Yolanda Jackson. From Jackia Dixon, who is Yolanda Jackson's daughter. Jackia is spelled Jaqkia, Dixon, Dixon. Good morning, Judge. I would like to say this situation has affected my everyday activities, and I can't sleep nor function properly now. My mother was my best friend, and I was always with her if I'm not at work or with a friend. My mother was not happy with this guy at all. She was being abused physically and mentally behind closed doors daily ever since she met Adonis. My mother was very afraid of him. She was so afraid that she didn't tell anyone about the abuse that she was going through at the time. I feel he should not get a bond because he's on video proving that he beats and controls her, and she wasn't even fighting back or trying to defend herself. He is a very dangerous and violent person. He was even on drugs, the same drugs that was found in his pocket at the time my mother passed, which is powder. My mother meant a lot to a lot of people. She has kids, a mother of her own, and siblings as well. This is something that sums up to be what is done in the dark always comes to light. I hate that losing my mother was the end result of this all. And at the end of the day, if he would have kept his hands to himself, we wouldn't be here today. We lost someone that's not coming back due to someone else's actions, and now he should be denied bond until he is fully convicted of his crime. And then we have from Katie Rutledge. This is the mom, Yolanda Jackson's mom, Katie, Katie Rutledge, Rutledge. My name is Katie Rutledge, mother of Yolanda Jackson. On February 15, 2020, Yolanda Jackson lost her life at the hands of Adonis Hurd. Words cannot express the hurt and pain and anguish our family and friends have endured since her murder. Adonis's decision to take the life of my daughter with no regard for the effects it may have on others as well as on his own life is unimaginable. The pain from the loss of my only daughter is beyond words. I will never get to see Yolanda again. Her children will never get to see her again. There will be no more birthday parties or family holiday celebrations to share. I will never get to hear my daughter's voice again or hear her laugh again. I will never be able to hug her and comfort her. The opportunity to say I love you is forever gone and our family is forever broken. Compassion is a word commonly used for defendants. However, I ask, how much compassion did Adonis have when the decision was made to hurt my child? It is the request of the family that no bond be granted today. Thank you.
Thank you, Ms. Rolak, and thank you to Ms. Jackson's family members. Do you know, is Ms. Jackson's daughter adult? Is she out of school or what? I don't want to ask how old she is. That's impolite, but is she an adult?
She's an adult and she is working.
Okay, thank you. Okay, I appreciate that. So Here's why I am, Mr. Hudson. I don't think that your client is a flight risk, and that's the main factor that I'm told by the appellate courts to consider. I think he would have trouble fleeing physically because of his medical situation. He has ties to the community. He's got family here. His kids are here. So on that one, I think I could set a bond that would address my concerns. I am less persuaded on the issue of the risk to the community. And what I'd like to do is to be able to watch this video, because I have two very different descriptions of what happened at the Lakewood MARTA station. And so what would be easiest is if Ms. Beza was able to get a copy of the video to Ms. Nelson so I could see it. But I want to let you know what my intent is, because you're free to object to that, in which case Ms. Beza, I'm going to give her a chance to lay a foundation for it and get it admitted. But I think it's important for my analysis to see what that shows. And I appreciate that it's silent. It doesn't provide context, but I've had not quite diametrically opposite, but very different descriptions of what was happening and the voluntary, playful nature of it versus a different description, and in particular at the Lakewood station. I don't know about West End, but whatever happened at West End didn't result in either Ms. Jackson dying or Mr. Hurd being seriously injured. So what I'd like to do is be able to review that, and then I'll be in a better position to make a final ruling on whether I think there is a set of conditions that I could set that would address my concern across the four factors. And I'll note, in case you wanted to make this argument, Ms. Beza's concern about intimidating witnesses is hypothetical. There's no evidence yet that that's happened. That doesn't mean it is an unreal concern or a misplaced one, but I'm focused more on the risk to other folks because of what I've heard described today. So that's where we are. I do want to add this for Mr. Hurd's benefit. We are doing what we can to get jury trials back up. We will have our first jury trial, the Chief Justice of the Supreme Court willing, on March 15th. And once we get a couple of those under our belts, we will be able to get moving more. Because Mr. Hudson has filed a speedy trial demand on your behalf, your case will get some priority. It's not the only one with a speedy. And while you no doubt feel like you've been in jail for an awfully long time, there are others who've been in even longer. But there is light at the end of the tunnel if the way this case does need to resolve is for a jury to decide intent, because it doesn't sound like some of the facts are in dispute, but someone's going to need to work through, was this a tragic accident, which is what I'm hearing from Mr. Hudson, or was it a vicious assault that resulted in the loss of Ms. Jackson's life and all the pain and suffering that we've heard about. So that won't be my decision. That'll be a jury's decision, unless the attorneys decide that it should be a bench trial. In the meantime, Ms. Beza, are you able to get the video to Ms. Nelson? I don't know if it's a 9 million gigabyte file, if it's something that can be emailed, or if you'd need to drop a thumb drive off at my chambers.
Yes, I can see if it can be emailed. If not, I would drop a thumb drive off. I'll be in contact with Ms. Nelson at the latest tomorrow morning.
Okay. That's a reasonable timeline. I assume you have this. I know that you worked hard to get discovery, and Ms. Beza's predecessor didn't necessarily get you everything you needed, but I did hear you this morning say, thank you, I think I have everything.
I do have everything, Judge. I have yet to look at the video, and I don't object, Judge, because I want to get to the truth too. I don't object to the court, viewing the video to make a ruling.
Okay.
I mean, we still got this, and Judge, the speedy is a backdrop, meaning if we have to go to trial, we can, but it will promote Ms. Beza and I to have conversations.
Agreed.
Now I can take it to Ms. Willis, and we can just all come to some type of agreement.
Yep.
And that way, I just didn't want Mr. Hurd to be sitting in jail 3 and 4 years waiting on a resolution of this case.
Sure, and it won't be that long. I can assure you that, but I appreciate that's a way to ensure that the case gets the attention it deserves.
Okay, thank you, Judge.
All right, so That's what we'll do. I've got the address where Mr. Hurd would be staying, so I won't need to get more information from the defense if I am going to set a bond. And if I'm not, I'll articulate that as well. Mr. Hudson, anything else on behalf of Mr. Hurd at this time?
No, y'all.
Okay. Ms. Besa, anything else?
No, Your Honor.
Okay. And Ms. Rolack, thank you again for giving voice to the concerns and the feelings of Ms. Jackson's brother, daughter, and mother. All right, that's it. Thank you, everyone.
Thank you, Ms. Nelson. I know she really been here.